Graduate of Osgoode Hall. He's been practicing for many, many years. In 1997, he demonstrated the E-Reg program at a Law Society seminar. And since 1989, Alan has been writing a weekly column in the Toronto Star dealing with real estate and mortgage issues. Alan is going to speak to us on how E-Reg affects an offer to purchase. Alan?
Good morning, everybody. If this talk was being given by Monty Python, he probably would say, and now for something completely different. And I say that because you've been hearing a lot about legislation and regulation and law society rules and guidelines. Now we're going to look at the contract, the arrangement between the parties, what the parties agree to when they sign up. And of course, we're not involved too often in that stage, but in any event, this is what we have to deal with. There are three types of clauses that are in use today dealing with E-Reg. Number one, that's better, we have what the Ontario Real Estate Association has done for most resale transactions. We also have what the Toronto Home Builders has done in their standard form offer. And a lot of builders who don't use the Toronto Home Builders form have developed their own clause. Every clause is different. They deal with the same issue differently. Some issues are not dealt with at all in certain contracts. I want to go through them from 10 different perspectives. I've put each of the clauses into the paper so that you can refer to it when you read the paper, hopefully at some point, but I've highlighted during the course of the paper the various points that I want to raise. So here we go. Number one, if it's an E-Reg optional jurisdiction like Toronto, what happens? The area clause is silent, which means that unless both lawyers agree, you close via paper. GTHBA says it's strongly implied that if the transaction is going to can close by E-Reg, it will close by E-Reg, and the builder offer says the seller's lawyer alone decides if E-Reg is going to be the vehicle of closing. And again, you can see three different positions. Retaining a lawyer, point number two. AREA, ironically, does not make it mandatory that there be a lawyer retained. However, if you go through the contract, you'd see if an institutional mortgage is being discharged, there is a need for a lawyer. GTHBA says buyers must retain a solicitor in good standing with the Law Society, and the same with the builder offer. Use of the DRA. Now, you've heard this morning that the DRA is often used, but it's not always signed. The AREA contract talks about the use of the DRA, and it does not make it mandatory that it be signed, and that would allow the London Middlesex arrangement to be used, which says that we agree to adopt the DRA, the most recent form of DRA, when we are doing our closing. The GTHBA offer says that the vendor's solicitor's form of DRA would be used, as does the builder's. So unless the parties agree to adopt a form of DRA, looking at those contracts, it looks like you'd have to have a signed DRA and could not operate with a paperless DRA. Point number four, what happens if you face a situation where there's a refusal to close an escrow under the DRA? Looking at the AREA form, unless the parties agree to the contrary, the deal would then close at the local land registry office. It's a misconception to think that the defaulting party would have to go to the non-defaulting lawyer's office, or the lawyer who has no computer in his office would have to go to the other one. It doesn't say that, and it doesn't even say that in the Joint Committee report. So the AREA form basically says if you can't close for some reason in escrow, you're back to the LRO. The GTHBA offer and the builder offer are very similar. If the purchase cannot be completed in escrow pursuant to the DRA, buyer's lawyer has to go to the seller's lawyer's office, and they even spell out how the seller's lawyer can set the time when you have to come. So just be aware of that if you're working with a GTHBA or builder offer. Electronic funds transfer, point number five, and Kathy Waters just talked about that this morning. Under the AREA offer, nothing said. Under the GTHB offer, nothing said. Under the builder offer, it is possible to have it, but nothing gives the seller's lawyer, the builder's lawyer, the right to require the use of the electronic funds transfer. It's one of the options spelled out in the contract. Presumably that means that unless both lawyers agree they want to have an electronic funds transfer, it's still going to be hard copies of checks that are delivered on closing. Tender. I don't want to spend a lot of time on tender, although a fair number of pages of my paper are devoted to it. The Joint Committee back in 96-97 said the issue of tender was not within their scope. And that's what AREA has done. They don't talk about tender in an E-reg transaction at all. Ironically, it's important to keep in mind that although documents are often faxed in a resale transaction, there's nothing in the AREA offer that says that that is to be the way documents are delivered. And the DRA paragraph 8 says that nothing in the DRA is to alter the rights and obligations of the parties or add to them or take away. And if there's any conflict, the offer prevails, not the DRA. I think that means that if you're in a tender situation, you cannot rely upon fax documents. You'd have to rely upon hard copies. The GTHBA and builder offers give us a lot of guidance what will be done on a tender, and again, they're worth reading simply because you'll get some ideas of what to do. GTHBA talks about signing for completeness. When the vendor's lawyer signed for completeness, that is sufficient in terms of signing the document. The question is, does it really have to be the vendor's lawyer, or could it be support staff? I don't know, but the bold wording of the contract says vendor's lawyer. Keys, another important issue on a tender. GTHBA says keys can be released on closing, that's fine, but it also goes on to say that advice that the keys are available constitutes a valid tender of possession. So the GTHBA contract goes on to say, as I mentioned, tender of keys because they're available at the sales office is adequate, or the availability is adequate for a tender. The builder's offer takes a little different approach. There's 3 points that have to be dealt with in order to be a valid tender. Number one, the documents have to be delivered along with the keys, and I'll get back to the issue of keys in a second. Number two, the builder's lawyer has advised the buyer's lawyer that they're ready, willing, and able to close, and the deed has been signed for completeness. Again, it has to be signed by the vendor's lawyer. Does that really mean vendor's lawyer or support staff? Keys. In looking at the GTHB offer, I mentioned how the availability of keys is in the contract valid tender. It doesn't quite say that in the builder offer, and therefore I'm wondering if it would be necessary to have the keys produced on a tender, because the builder offer does not go as far as the GTHB offer that says the availability of keys is not only good for closing but for tender. Again, we don't know. We're going to learn in the future when these issues are resolved by a court. Some of the guidance we get from these clauses: the deed has to be signed for completeness, preferably by a lawyer. The normal rules of tender apply in most circumstances. Don't send documents by fax unless specifically it's allowed in the agreement of purchase and sale. Silvana has prepared a paper a couple of years ago. She made a couple of very good points. Number one, if you're going on a tender, take along your PSP in case it's necessary to re-sign because of any changes that have been made. And also, it's prudent to have a paper copy of the signed electronic document and the acknowledgement of direction as proof of authority to close or tender on an E-reg. Mortgage discharges, you've heard Kathy Waters talk about that. The AREA forms sort of have changed it and adopted what Kathy said, and it's unfortunate Maurizio's not here. Oops, I'm a little behind my hitting the button. The new resale offer says that the discharge, the undertaking that you give is to discharge the mortgage or cause it to be discharged. For some unknown reason, those words, or cause same to be registered, are not in the condo offer, but they're in the commercial offer. So I hope Maurizio and his people will take it up with AREA that somebody missed it, and in the next version, the condo offer will be consistent with everything else. GTHBA and builders, most times the mortgages are discharged shortly after closing, if not on closing, so they're silent on the issue. Electronic payment of discharge funds, not just the delivery of funds, but the discharging of the funds. The way the AREA offer is worded, real-time transfer of funds is permitted, but if it's not being used, we're back to the hard copies. So therefore, hard checks will be delivered unless both the lawyers agree to an electronic transfer of funds. Ironically, GTHBA and the builder offer are silent on this point. Point number 9, preparation of documents. Traditionally, it's been the seller's lawyer who prepares the deed, but what evolved out of Middlesex is a reversal of the procedure where the buyer's lawyer prepares the deed because they have all the information, everything is pre-populated, and all the sellers would have to do is insert a couple of things like post-closing address of service, spousal statements, and planning act possibly. The Joint Committee has asked AREA to change their offer, and I don't know where we stand on that, but that is a request that has been made. Of course, the parties can agree to the contrary, in other words, to have the buyer's lawyer prepare the deed, but it's not in the AREA offer per se. GTHBA and builder basically, the builder's lawyer will complete the preparation of the deed because often you have a new legal description or a lot of complexity in the legal description which only the builder's lawyer can provide rather than the buyer's lawyer. And my last point, miscellaneous. I've taken 2 clauses from 2 large builders, and it's kind of surprising what you see here because this is what's out there and you've got to read it carefully. One of them wants $50 if you're going to close E-Reg. It's $50 now for the transaction levy and $50 now to close E-Reg. You've got to advise your client or try and get it knocked out. Another clause said they want the money the day before closing. Now, ironically, we didn't close this transaction, E-Reg, but I don't know what I would have done. To get the client's money, possibly, the builder's money, you tell me, sorry, the bank's money, you tell me any bank is going to release the money a day before without registered documents. And the last point I want to raise is often it's necessary to register an agreement of purchase and sale on title. And if you've been in practice for 25 years like I have, you've gone from the assignment of agreement of purchase and sale to the notice of agreement of purchase and sale to a caution. A couple years ago, the government threw all that out, and they changed the rules on registering in land titles the agreement of purchase and sale. It is now a form of caution. In an appendix to my paper, I've attached the bulletin that deals with the issue. A couple points I want to deal with. Number 1, you have to be prepared to produce the agreement of purchase and sale for inspection. So you register the caution in the cautions module, but you have to be prepared to produce it. Number 2, it only sits on title for 60 days. And number 3, it does not activate the no dealings indicator. Years ago, you put an offer on title when there was any concern about something happening with the property, and you basically froze title. Not anymore. So somebody could buy the property and know that after 60 days, the caution is going to automatically be deleted by the registrar unless something is done to extend it. So it's a totally different scenario than we faced a couple of years ago. I was very fortunate to do the demonstration and honored to do the demonstration back in November 1997 about E-Reg. And the only thing I can say is it is an evolving process. It is a process that is constantly changing. The contracts, the clauses I've put before you today will probably be different 5 years from now, just like the way we handle a lot of issues with E-Reg is different today than it was 5 years ago. So all I can say is when I'm doing some radio stuff is stay tuned. Thank you.
Thank you, Ellen. That was very helpful, and we might need you in a few years to take us through it again, as you say. So, our next speaker is Bob Vernon. Bob is now a sole practitioner after 24 years as a partner with Lang Michener here in Toronto. He practices real estate and municipal law with an emphasis on condominiums, life, lease, housing, and real estate financing and conveyancing. He's a former chair of the Electronic Searching Subcommittee and currently a member of the executive of the Real Property section of the OBA. He will speak to us today about the possible pitfalls with title searching in the electronic registration system. Bob.
Thanks, Silvana. Kathy Christie has already covered the registry office non-converts issue, and Mark Durward has told us a bit about when you have to go to the registry office. I will try to avoid overlapping, as I might have been inclined to, with what they have said. But my remarks will essentially be confined to remote searching of automated titles under the Land Titles Act. Subject to a few deficiencies that I will mention, the current system works extremely well, and I know that from personal experience. Now, as a sole practitioner, I search virtually all my own titles. Just as a reminder, electronic titles, inland titles, fall into one of 3 categories. And I've set out some of the details of the differences between those in my paper, but I'd like to just repeat the 3 categories because I'll refer to them in my comments. Land titles absolute, LTA for short, land titles conversion qualified, LTCQ, and in a rare case we see land titles plus. For purposes of identification, you should keep in mind that the LTCQ parcels bear the notation LT conversion qualified under the estate qualifier. Although the other two categories both bear the notation absolute, you can tell an LT plus parcel from an LTA parcel by the fact that the LT plus parcel always has a prior but inactive LTCQ parcel. And that can be accessed remotely, directly or indirectly through the PIN number shown under recently on the parcel register. Title qualifications are the things that make the important difference between the three categories of land titles parcel. Unless the contrary is expressed on the parcel register, section 44 sub 1 of the Land Titles Act makes titles subject to a number of existing liabilities, rights, and interests, which are detailed in the legislation. In my mind, the most important of these relate to the subdivision and part lot control provisions under Section 50 of the Planning Act, possessory and prescriptive rights, and the rights of adjoining property owners. Now, if your property is LTCQ, the parcel register, of course, gives you some relief from Section 44, but it will also introduce some additional qualifications. You do get relief from the very dire consequences of prior contraventions of Section 50 of the Planning Act, as cheats and forfeitures to the Crown. However, you have two new areas of concern. The first relates to unregistered leases up to 7 years in length. More importantly, however, the qualification that reads, the rights of any person who would, but for the Land Titles Act, be entitled to the land or any part of it through length of adverse possession, prescription, misdescription, or boundaries settled by convention is very, very important. This carries over to the land title system possessory, prescriptive, and other rights not previously recognized under the land title system. And that simply reflects the fact that the administrative conversion process did not involve a formal application, a current survey, or a notice to abutting owners and other interested parties. In the rare case where your title is Land Titles Plus, you needn't worry about those latter two qualifications that apply to LTCQ. I'd like to now address a number of the major pitfalls in electronic searching. And I'm going to address Section 50 of the Planning Act once again, legal descriptions, prior corporate owners, current ownership, the thumbnail, and I'm going to revisit a bit what Mark said about documents that aren't available when you're doing your search remotely. I would also like to underscore the importance of obtaining full parcel registers, including all deleted instruments for both the subject property and the abutting lands. It just isn't possible to do your search without those. As you all know, Section 50 of the Planning Act has really been the bane of our existence for a long time. Planning Act searches were simplified enormously back in 1984 with the introduction of the Land Registration Reform Act and its provision for Planning Act statements. And of course, our difficulties were simplified significantly once the property was converted from registry to LTCQ. It means you don't have to go back before the date of conversion. The key thing is, again, remembering which category you're in. In LTA, Land Titles Absolute, you must undertake the full Planning Act searches in respect of all abutting lands. except where there's been an intervening transfer with properly completed Planning Act statements. And this can sometimes mean going back to the paper records as well as sometimes 2, 3, or even more prior automated parcels. That is, of course, unless one of the specific exceptions in Section 50 applies. And again, the only way to effectively do the Planning Act search, as you know, is by plotting all the legal descriptions to scale to determine whether any abutting parcels have been missed. It's not sufficient to rely on the property index maps or on the list of adjacent properties that are generated by the search. In the case of LTCQ or LT plus properties, it is at most necessary to go back to the point of conversion. And in many cases, the Planning Act statements will further reduce your efforts. One thing that should be remembered, it seems to be the normal practice to make a note on the parcel register if a transfer contains Planning Act statements, but my observation is that that doesn't always occur. Legal descriptions certainly require special attention. Noted at the bottom of every land titles printout are the words, "Adjoining property should be investigated to ascertain descriptive inconsistencies, if any, with the description represented for this property." Except when you're dealing with the whole of a lot or a block on a plan of subdivision, that investigation should be conducted in each and every case. And again, the only way to do that is to plot out the legal description of your property and the abutting properties. This was underscored to me a short while ago when I happened to check the title to my own office building and found to my amazement that in the conversion process, somehow an easement had appeared that ran right through the building. And when I get time, I'll have to take that up with the Terraview people. I'm afraid things like that get left for the last moment. The other thing I'd like to stress is that while people have a tendency to assume that with land titles absolute and land titles plus, that title is guaranteed both as to ownership and to extent. That isn't the case. And you should take a look and consider Section 140 sub 2 of the Land Titles Act, which provides the description of registered land is not conclusive as to the boundaries or extent of the land. I was going to make some comments about prior corporate owners and those searches, but I think Mark dealt with that in his presentation. Although I would like to point out that there does seem to be an inadvertent error in my paper on page 5 in respect of land titles LTCQ and land titles plus titles. You only have to go back for corporate owners to the point of conversion from the Registry Act. Those last 10 words somehow disappeared from my paper. If the property is an LTA, of course, it's theoretically necessary to go back at least 60 years to confirm there have been no escheats to the Crown. Although I would suggest that very few lawyers do that except in exceptionally large transactions. Property description, or the thumbnail as it's often referred to, is a deceptive term. It contains a lot more than just the description of what you're dealing with. For some strange reason, writs of execution that may affect current or former owners of the property that turned up in the administrative conversion process are recorded not in the instrument section of the parcel register. They appear in the property description, and I'm sure you've all seen it. It reads something like, subject to execution number so-and-so, if enforceable. without the slightest indication of the name searched against or the name of the judgment debtor. And that can be quite a nightmare when you try to get that off title. If the writ of execution has expired without being renewed or has been withdrawn, then when you try to search by number, you're simply told that the writ does not exist on file, or writ not found. And for a while they were insisting on applications to delete such writs based on evidence that you couldn't provide. And now they're prepared to accept a statement or an affidavit to the effect that a search of the Ministry of the Attorney General's database has been conducted and one of those messages received. Similarly, you'll sometimes see references to outstanding spousal interests, debts of deceased owners, and other interests arising from pre-conversion deficiencies, and those have to be carefully noted and applications to amend requisitioned. My big frustration with electronic searching are the situations that prevent one from completing an electronic search on a timely basis, or at all. Mark has commented on the difficulty in trying to complete a search when in the thumbnail there is a reference to an instrument which you can't access remotely. The good news, I understand, is that this problem has been addressed and will be resolved in the next version of TerraView. I'm not quite sure how it's going to be resolved. The other frustrating thing, of course, is the delay in imaging documents after they've been registered. Since I've been handed one reminder, note that I'm approaching the end of my time and I anticipate another one. I guess I'd like to just finish off with two reminders, which I'm sure you all take into account. First, in doing your search, all instruments, including plans that appear to or are referred to in the parcel, whichever type of land titles title you have, must be obtained and carefully reviewed. You should take nothing for granted, and I've given some examples of why you can't take anything for granted in my paper. And secondly, it's not always sufficient to simply confirm that the last instrument on your search of title is the most recently registered instrument on the parcel. Deletions, corrections, and amendments can be made both by application and by the land registrar. If you're relying on a document being there, be sure to conduct a new search of title at the time of closing. I hope that's been of some assistance to you. Thanks.
I've always thought it ironic that in Ontario we had two systems, registry and land titles, and to simplify, we now have 3 land title systems. But as Bob has pointed out, each has its own characteristics, and failure to search appropriately has serious consequences, whether you incur expenses for your client that you don't need to, or whether you miss searches you should do. So Bob's review is most helpful. Thank you. Silvana D'Alimonte, my co-chair, is a partner at Blake Castle. She has been on a number of these sessions, both with me and others, speaking on E-Reg and many other issues. Today, Silvana is going to speak to us about requisitions when you're operating in the E-Reg environment.
Thanks very much, Rosemary. My topic is this special requisition letter clauses. You know, and as I thought about it, I came to the conclusion that there really aren't special clauses that arise out of or are necessary because of electronic registration. Requisitions are requisitions, be they title or contract-related ones. I mean, it's true there are title problems that have been created because of this conversion process. Bob mentioned a few with the stuff that happens in the thumbnail description, a subject to an execution, subject to some instrument we can't find. But that's not unusual. I mean, that's not a special clause. That's something that has arisen as a result of our review of title that we will want to requisition the deletion of. So then you're saying, so what are you going to talk to us about today? Well, I think just some practical points and tips, I think, some of which have already been covered by some of the other speakers, but perhaps just bear repeating. Firstly, in jurisdictions where electronic registration is still optional, such as in Toronto, I think you're going to want to ask in your requisition letter if the vendor solicitor wants to, in fact, do the deal by e-reg. You may find, there's a lot of resistance still, but hopefully that'll change over time. Secondly, in your requisition letter, set out if you're going to prepare the electronic transfer or not. Now, of course, that's provided you have a choice. If your client is buying from a builder, the builder's lawyer is going to want to prepare the transfer. And then let the vendor's lawyer know to whom electronic documents should be messaged to in your office and to whom you should message electronic documents to them in their office. Now, on this business of who prepares the transfer, I think Alan referred to this. It's true, Maurizio 2 weeks ago in his little Canadian Institute talk did say that generally in e-reg practice, and I guess maybe he's talking about London, that the purchaser's lawyer prepares the transfer. So what's happened then is that the Joint Committee on the Electronic Registration of Title Documents has requested a change to the AREA form of purchase agreement to indicate that the purchaser's lawyer will prepare the transfer and the VTB, if any. But apparently, according to Maurizio anyways 2 weeks ago, this change is unlikely to be included in the newest version of the AREA form. I think we'll have to wait probably for the next generation. Now, I don't know if there's an e-reg practice in Toronto yet on this point, but I suspect it will evolve, and I imagine that the recommended change to the AREA form will help shape the practice. Now, thirdly, even if you are going to prepare the transfer, it's still useful to set out in your requisition letter how the purchaser intends to take title so you can facilitate the preparation of non-registration documents by the vendor's lawyers. Now, fourthly, this one small point, if the requisition letter still says, please complete box 13 of the transfer, well, that's something you can actually update, a small little change. I think what you should do is just put in language that requisitions that the vendor's lawyer complete the Planning Act statements in the transfer. I think this works in both, e-reg and non-e-reg world. Now, fifthly, you can include a draft, or for that matter, a signed DRA in your requisition letter, or if you want to go the way London has gone, you can propose to the vendor solicitor that you exchange a letter agreeing to be bound by the protocol. That there's a DRA that's posted on the Law Society website will be bound by that protocol. So it's an acceptable method. It's just a matter of whether it's going to be picked up here in Toronto. You can try it. We can be the guys who start the process. And then sixthly, I think it's this BMO thing. If you're lucky enough, to have a trust account at the Bank of Montreal, I think you want to raise with the vendor's lawyer, are you guys part of the program? Can we actually do this sort of real funds, real-time transfer or not? I think for now, anyways, I think we're going to be dealing with the old-fashioned method of certified checks for a while, but hopefully that'll change over time. And now what I'd like to do is just spend a couple of minutes on standard closing documents and vendor take-back mortgages. Now, on standard closing documents, I understand that in London, probably more than half of the residential real estate practitioners have gone to using standard forms of non-registration closing documents. I also understand from our Ottawa office that a standardized all-in-one document has been used for about the last 5 years. Hamilton is moving in the same direction. Mark, who spoke to us from Hamilton today, tells me that there are standard forms there as well, the use of which has been endorsed by the Hamilton Law Association. I've included the standard forms from these 3 cities at the back of my paper. You may want to review these forms with the lawyers in your office to determine how you can consolidate or standardize your forms to the extent that you haven't already done so. And then in your requisition letter, what you could do is request the delivery of the standard forms that you provide. Now, in a jurisdiction with a large residential real estate bar like Toronto, it's going to be more difficult for sure to get widespread acceptance of any one set of standard forms, but it probably is worthwhile to try to standardize non-controversial documents. And then finally, I just want to spend another minute on vendor take-back mortgages. Now, although a vendor take-back mortgage, well, you probably know this, but although it's a 2-party document, the electronic form is signed only by one party, the charge or purchaser. So what does that mean for us? Well, firstly, this means that if the purchaser's lawyer electronically signs the mortgage on behalf of his client and then registers it, if the mortgage is subsequently returned from the registry office because there's some problem with it, whatever it might be, the mortgage is returned to the purchaser's lawyer because the purchaser's lawyer signed it for completeness. Now, this could cause a vendor's lawyer some concern. Number one, you don't know that the mortgage has been returned. Number two, you're relying on the other side to fix the problem. This is problematic. And secondly, since the vendor's lawyer has no ability to sign the mortgage on behalf of the vendor, this has to be an unscrupulous purchaser's lawyer, but, crazier things have happened. The purchaser's lawyer could amend the form of mortgage before registering it without the vendor's solicitor's consent. Whereas, as you know, when you've got a two-party document that requires two signatures, such as a transfer, if both parties have signed and then one party makes a change, removes the signature of the first party, and then you can't register the document until both have re-signed the document. From a purchaser's perspective, what I do as a purchaser's lawyer, in the requisition letter, I'd probably say, look, I'll prepare the VTB and I would propose to register the transfer and the mortgage in accordance with the DRA. And hopefully for most residential real estate deals, this will work. But you might encounter a vendor's lawyer for whom this is not acceptable, who wants to control registration of the mortgage. So if I had to flip from the vendor's perspective, then if I wanted to register the mortgage, I'd probably also want to register the transfer as well, as bizarre as that sounds. Because if I let the purchaser register the transfer and then I register the mortgage, there's a chance of an intervening registration. And if that happens, it's too late to fix it because the property's already been transferred. So to accomplish this, what the vendor solicitor would likely ask you to do is to say, I want your client, the purchaser, to sign an acknowledgement and direction addressed to the vendor's lawyer, authorizing the vendor's lawyer to sign and register the mortgage on his or her behalf. Now, what about this transfer? Do you really want to register a transfer? What about the fees? It is possible, I understand, on the system that vendor's lawyer can register and you can designate that the purchaser's lawyer's account will be debited for land transfer tax and registration fees. So it is possible. Now, you may also find, as I did on a recent transaction, that the solicitors for a lender who were providing purchase financing wanted to control registration of the mortgage. And so they similarly requested me. I had to get my client to sign the acknowledgement and direction addressed to the lender's solicitor, and they registered my transfer and their mortgage. Now, of course, the other option here where there's fighting for control of who's going to register is just old-fashioned way. Attend at somebody's office on closing and just look over their shoulder as they proceed to register the documentation. This whole process, as you can see, is a little bit cumbersome. I think the potential solution here is to make this mortgage a two-party document that can be signed by both parties. Randy Reese reminded me earlier on that, in fact, when the form of mortgage was first introduced, it did provide for signature by both sides. And when it was, piloted out in London solicitors screamed and saying, this is ridiculous. Why do we need to have it signed by both sides? Because in most residential real estate deals, you act for the purchaser's lawyer acts for the purchaser and the institutional lender. You don't really need the two sides signing. So they changed it to only one side signing. Well, it doesn't work in all cases. So apparently it is on the ministry list of priorities to introduce another document type, which is a mortgage that provides for signature by both sides. So I think that will be helpful. In the meantime, though, I did want to flag these issues with you because you might encounter it. And that's it, guys. I think we made up some time. Thanks very much.
Silvana, thank you very much. Historically, requisition letters were to deal with title issues. But as we all know, for years and years and years, we've dealt with administrative matters. And I think, as Silvana's pointed out, there are many new administrative matters that we should look to. So thank you, Silvana, for your thoughts.
Now I'm going to introduce our next speaker. Now, as you know, there are those lawyers who actually do the law thing first and then decide to go into politics. Well, Stephen decided to do it in reverse. And so he's thinking, this is what you have to profile for me. Well, it's the most interesting thing. At the age of 18, Mr. Willard was elected councillor of the township of Amherst Island, and 3 years later he became reeve. Now he's gone. He's an associate with the Gowlings, and I've had the pleasure to work with Stephen before. Stephen, if you could come and chat with us.
Yes, thank you, Silvana. I was actually lucky enough during my articles, I was able to work with Silvana and thoroughly enjoyed it. I've been asked to speak on statements of law that are made in very specific transactions, primarily vesting orders coming out of bankruptcy and estate conveyancing. Now, having said that, on my way over here as I crossed Bay Street, a hearse flew by me, and it's the first time I've ever seen a hearse on Bay Street. So I hope that was a good omen. I think people would probably carry them out as opposed to using a hearse. As I'm sure you're all aware, statements of law in the system are only to be made by lawyers who hold a legal account. This is a very important aspect of the system, and the system is premised on this. But of course, we all know that the law clerk's going to be largely preparing the documents and of course preparing the evidence that goes behind those statements of law. So that's what I'm primarily going to address is what you need to have so the lawyer can make those statements. Because this is largely dealing with vesting orders and estate conveyancing, I'm not so much speaking to you as a real estate lawyer, so much as a conduit from my colleagues who advised me on these things. And needless to say, when I advised my friends in the estates department and in the bankruptcy department on the nature of some of these all-encompassing statements of law, they laughed themselves hysterically and said that they would never make them in 100 years. Unfortunately, we have to. The first item, I guess, is vesting orders. Statement 501, which is a statement of law, requires that the solicitor guarantee that the order is in full force and effect. The important aspect here is the court will issue the order, and as soon as it's issued, it's like milk on the counter. It's starting to go stale. The bankruptcy and insolvency lawyers tell me that it is very likely that if an appeal is going to be made of that vesting order, it will be made the day that the vesting order is issued. So as soon as you get it in your hot little hands, you're going to have to register it. If necessary, you're going to have to do a search at the court to confirm that no appeal was lodged. Now, the insolvency lawyers tell me that it isn't necessarily the case that an appeal will stay a vesting order, but 99.9 times out of 100, the sole purpose of any appeal will be to stop you from registering that vesting order. So when that vesting order goes on title, the lawyer who is signing the document has to confirm that that order is in full force and effect. So my advice is register it as soon as possible. If it becomes necessary that you have to register a vesting order days or weeks later, then you must undertake a search of the relevant court records to confirm that no appeals have been lodged. And when you do that, of course, keep excellent notes in the file of when the search was done and what time. If there is ever a question later on that the court order had been appealed, then you've got the proof that, yes, we did the search at this point in time. In vesting orders, because of the nature of them, they go on title and basically exterminate certain registrations that have gone before them. One of the most useful practice points I have found is hold a conference call with a representative of the land titles office that you're going to be registering in, together with the solicitor or the law clerk representing the party that's going to be getting the property. Then you can have the form of the vesting order pre-approved, and most importantly, you can have the land titles office confirm what instruments are going to be deleted. It's not much fun when this thing is registered and then a week later you get a phone call from the party representing the vested owner saying, oh, well, they haven't bounced or removed these instruments. It's well worth spending the 15 minutes getting that lined up. When you register the vesting order, the important thing is to register the whole order. My friends in the litigation department tell me that you have to register the whole order. If you register a part of an order, it's as good as not registering it at all. Where this will create problems is where your purchaser has entered into an agreement of purchase and sale, and that agreement of purchase and sale is appended to the court order as a schedule. they may not necessarily want that agreement of purchase and sale showing up on title, but it does actually constitute part of the court order, and you have to register it. Estate conveyancing. One of the most common statements that needs to be made is Statement 601, which is the date of death. Anybody who does estate conveyancing knows that usually what you're relying on is the proof of death certificate that is issued by the funeral home. And this is actually a certificate that is authorized by the province of Ontario that certain people can make, and it is certainly good evidence of the date of death. If a proof of death certificate is not available, your other option is a certificate of death, which is issued by the province of Ontario from the office in Thunder Bay. The problem with that is the death certificates are often only issued about 6 months after the date of death, so there's a bit of a delay. Apparently, you can also use a coroner's ruling if the death was under certain circumstances where the coroner has become involved. Where you're also going to have trouble in this area is where you have to register based upon the certificate that was issued by a different jurisdiction. I can give you an example of a gentleman who died in the state of Alaska but owned property in Ontario. He was actually in the woods at the time and was found dead. The state of Alaska does not issue a certificate in such circumstances saying that the date of death was April 24th, 2003. They issue a statement or a certificate that says he was found dead on such a date, which creates a bit of a problem. The way you can get around this, and it's actually pretty ingenious, I can't say that often about the Terraview system, but you can register these certificates ahead of time and then rely on statements 610 and 611, which are not statements of law. And basically what they say is that it refers to the evidence that was previously registered as instrument number, whatever. So that's certainly one option. Most often, you're going to be registering orders appointing estate trustees, either with a will or without a will. These are statements 3512 and 3513, again, statements of law. Again, these raise the same issues as vesting orders. As soon as these leave the judge's hands, they start to become stale. Again, register them as soon as possible. If you have to register them at a later date and time, again, do a search of the court records to make sure that one of the beneficiaries or some next of kin has not gotten himself or herself a lawyer and decided to appeal the order of appointment. Again, the lawyer is going to have to confirm that when that statement is made, that order is a good one. The estates lawyers, when I mentioned statement 3513, laughed themselves senseless. This is the statement that is required to be made where there was no application made to appoint an estate trustee and the value of the estate is left less than $50,000. So not only do you have to practice law, you have to be an appraiser. The standard of practice I have discerned from speaking to a number of estates lawyers is have the next of kin or the principal beneficiary produce a declaration listing the inventory of the estate and assigning a value of it. You may be able to rely on that, and in most cases the value of the estate is going to be so much lower than $50,000 that it's probably a very safe thing to say. If there is some question as to the estate being worth $50,000 less 10 or more than $10, it's probably a good idea to have an appraisal done, and then the lawyer can rely on that. Again, it's a peculiar thing that the real estate lawyer has to certify the value of the estate. So you're going to have something in the file, either from a beneficiary or next of kin, confirming and certifying the value, or you're going to have to go to a third party. And it should also be noted that the value of the estate will be the value as of the date of death, not the date of the statement. Two of the more problematic statements that need to be made are 3508 and 3509, which deal with the property which is being sold or transferred, being subject to or not being subject to the debts of the deceased. Most often, you'll probably be making statement 3560, which says that the property is being sold to satisfy the debts of the deceased. Oftentimes, solicitors who are acting for the purchaser in such circumstances are going to want some sort of confirmation that the value or the consideration that is being paid is going to go to satisfy these debts. If statement 3508 is made, which simply states that the property is subject to the debts of the deceased, you can be sure you're going to be hearing from your purchaser's solicitor. They're not going to want to have that show up. It's a bit problematic. I have 3 minutes, and I think the next one is that you're boring them senseless, so wind it up. If the estate is subject to the debts of the deceased and the property is being sold, then you can probably safely make the statement that the property is being sold to satisfy the debts. If the property is not subject to the debts of the deceased, you'll need a statement from either the administrator or the beneficiaries confirming this. This is very important because obviously the beneficiaries have a legal right to the assets of the estate. It is very, very important that they sign off that the property is being transferred and that what they are owed has been settled. The best of all situations, which rarely happens, of course, is that the accounts of the estate have been passed by the court. And once you have that, then you can safely make the statements and rely on the accounts as being passed by the court. There are a few other statements that I did not include in my materials. Statement 3557, that all required parties have given their consent to the transfer of the value of the property of the estate. In this situation, what you need is to have the beneficiaries and the administrators sign the authorization and direction to show their consent. This may also become important. As you probably know, in estate conveyancing, do a title search. There may be documents on title that require the consent of third parties, such as charges and co-owners agreements, in which case statement 3726 arises, in which the lawyer certifies that that party has consented to the registration of this document subject to the continuance of the original registered instrument. Oftentimes people don't realize that, but you should do a search of title before you convey an estate's property. I think that's probably it. The last one is statement 3558. The personal representative has the authority to transfer the land under the terms of the will, if any, the Estates Administration Act and the Succession Law Reform Act. Unfortunately, this is one of those things where you can't really put anything in the file to support that statement. That is something that the lawyer will have to satisfy himself or herself. They'll need to confirm that the estate transaction that is contemplated meets the terms of those two acts and of the will. I hope that answers some of your questions. It can all be summed up basically in keep evidence in the file of what you're going to say and do.
Thank you, Stephen, for going through some of the more contentious compliance with law statements. Although law clerks, as you all know, don't make those statements, we all know that it's the law clerks who educate the lawyers that do. Next, we have Doug Cassino, who will be speaking to us from London. Doug's practice is concentrated in real estate and development law. Doug was part of the pilot testing project in Middlesex for electronic registration. And since Doug has practiced for almost 3 decades, he's living proof that we can all learn and adopt new ways of practice.
I hope you can all hear and see me. I'm going to talk to you very briefly this afternoon about 3 aspects of actually getting ready to register the documents. And that's preparing for closing, certain registration issues, and certain issues occurring post-registration. You've heard a brief mention about how you store your documents when you prepare them, and for those of you who have not had experience with the system yet, you'll find that it is set up in a docket system. And so the intention is that all documents relating to a transaction should be stored in the same docket so that you can register them sequentially. When you come to register, you'll see, when you ask the system to register, you'll see all the documents listed, and you can select the documents you want registered and the order that you want them registered. Those familiar with the system will know that it's for a two-party document. There's two parts to signing. One is for completeness, to make sure that the document will register, and the other is for release, to release the document for registration. My suggestion is that as soon as you've completed a document as part of the process in preparing all of your documents, it should be signed for completeness, so you know 2 weeks ahead of closing whether you've properly prepared the document or not. The practice in our office is that my assistant will, in a purchase situation, will prepare the transfer, because here in London we do that, and prepare the charge. She will sign each document to make sure they will sign, save as to any statements of law, which I may have to make, and then she'll remove her signature. And we do that for a couple of reasons. Number one, on a mortgage, it reminds me to review the mortgage and sign it and make sure that I've looked at the mortgage and it's in accordance with the instructions. Secondly, I do the majority of the registrations in my office, and the system is set up such that when I sign for completeness, whoever signs for completeness then has to go into the system to print what's called a document tax summary, which is a listing of the cost of registration. From what I heard this morning, perhaps the next issue of the TerraView will change that so that it doesn't matter who signs for completeness. Either the solicitor or his assistant can get that statement. You've heard this morning as well that statements of law must be signed by the solicitor, and that means the solicitor should be signing it with his disc and not assigning that task to his assistant. The solicitor must consider the law statement, because he is the one that must make the decision on that. My suggestion to make things a little easier for closing is do not insert Planning Act statements where they don't have to be inserted. You certainly don't need it in a transfer for a condominium. You must keep in mind when a statement of law or law statement is inserted in a document, certain changes will remove signatures, and if that lawyer is not available, then he's not there to sign. I tell you from experience, one thing you should be looking at pre-registration, especially if you're acting for a vendor, check the document to see who has been assigned the responsibility for paying for registration. In the system, the drop-down menu for the instrument, you can name your document, and you can also indicate which party you're acting for and who is paying for registration. I have, on a couple of occasions, acting for a vendor, ended up spending a couple $1,000s in land transfer tax that I didn't know I was going to be spending, and that was simply because someone had designated the vendor as paying for the registration cost of the transfer. So that should be the last check you make when you're acting for a vendor before you sign the document for release. Our practice in doing our getting documents signed for completeness, as I say, we do it well ahead of time. We don't wait until we go to register. You are going to have transactions that close at 10 to 5, and if you're struggling trying to figure out why the document won't sign, you do stand the chance that you cannot register by 5 o'clock. Another aspect, of course, is execution searches. The practice in our office is to complete the execution search first thing in the morning. I'm not sure. I think the posted hours for the system start at 8 o'clock in the morning. I can tell you I've been on at 7, 6:30, quarter to 7. It seems to be up early, but at 8 o'clock the curtain does come down. We search against purchasers / and my paper says mortgagees. That should be obviously mortgagors. Those searches are conducted in the RITS module, which if you're familiar with the system, you'll know that there is a separate module where you can search executions. Searches against transferors should be made within the instrument itself, because if you search against the transferors in the RITS module, the system will once again search against the transferors when you register the transfer, and you're going to incur the cost again. Keep in mind that when you search against the transferors within the instrument. In fact, it will search against the transferors within the instrument. So that if you're buying from an estate trustee, you will end up with an execution search against the estate trustee, but not the deceased. And so if you're relying on a transmission application that's been registered but not certified, you should be searching against the deceased in the writs module to make sure there are no outstanding writs. I don't recall that I've ever had a registration that I've been in the process of where I've had the flash screen that says if I continue it's going to be subject to a writ, but I think that is what happens. So if you see that flash screen, you should cancel your registration, determine what the writ is about and why has it occurred, and obviously resolve the situation. Subsearches, those of you familiar with the system knows that the default setting when you request the registration of a document, it will automatically subsearch and give you the last registered instrument. You can change that setting. There are very few circumstances I can think of where you would want to do that. You may be registering a document, for example, against 100 units in a condominium, and you may not be interested in what the last registered instrument is, and you do not want to take the time to have the system subsearch 100 units because that will take some time. So you may reverse the default setting there. Otherwise, you are obviously going to want to subsearch to see what the last instrument is prior to registering so that you can compare it with your search of title. So nothing's changed from the paper system in that regard. After you register, the system will display your registration numbers, and it will also print out paper copies of your registrations. My practice is to jot down the registration numbers just so I've got them on my title abstract. However, if you don't do that, and if for some reason you have a problem with your hardware where the documents don't print, you can go back into your docket, look at the instrument in progress drop-down menu, and it will tell the registration number of your document so that you can actually go back into the system and get copies for your files. Some solicitors, I believe, do not rely on the last instrument display as their subsearch, and will in fact go back in after registration, obtain a parcel printout so they can confirm the sequence of registration and that their documents are there. There is a cost associated with that, of course. Keep in mind in your subsearch, if you're buying part lot, you're going to have to subsearch again the adjoining lands to make sure that there is no common ownership that's occurred since you did your full search of title. Registration issues. Occasionally there will be documents that have to be registered prior to closing, but that weren't registered at the time of your search. Because when you register, the system will simply tell you the last registered instrument, and you may have that from the vendor's lawyer saying, I registered the survivorship application as instrument number so-and-so. That, of course, does not tell you if there were intervening instruments between your search of title and the last registered instrument or the instrument number that he's given you. A couple of ways of resolving it, of course, is to get another parcel printout prior to registration. The way we're handling it in London, if we have an opportunity, if I'm buying and there is an intervening document that has to be registered, such as a discharge, I will ask the vendor solicitor to message that document to me, sign it for completeness, and then I will register it in my package with my document so that when I go into register, I should not see another instrument after what I've seen in my full search of title. Vendor take-back mortgages, Silvana talked about that in some detail. You can see from my paper what we're doing in London generally, which is the purchaser solicitor is registering the vendor take-back mortgage after having the vendor solicitor sign it for completeness so that he bears the cost of registration. We then, just so the vendor solicitor can confirm registration sequence, I will fax to him or her immediately after closing the registered transfer and the registered BTB so that the vendor solicitor can see that there are no intervening registrations. Place of registration was mentioned briefly in other presentations this morning. Keep in mind that you do not have to be at your computer to register your documents. You can access your documents from any computer that has TerraView loaded on it, as long as you have your disk with you. It's been suggested to me that once your documents are registered, you may want to compare them to the drafts that you should have in your files to determine if there's something missing or an error between your draft and the register document. I'm not really sure how that could occur, other than if there were changes made that you did not note before you signed for completeness. Collateral documents, no doubt you'll be in this situation occasionally where you're acting for a purchaser, placing a mortgage, and a collateral document such as an assignment of rents. There is a method in the system of allowing you to, for example, in an assignment of rents, to have that assignment of rents registered with the registration particulars of the charge in it, without having to register the deed, register the charge, go back out, put the registration number of the charge in the assignment of rents, and then register. And there is a procedure that you can follow to do that. Post-registration, some discussion this morning was had about return documents. Keep in mind this is not an email system, so unless you're actually logged into the system, you're not going to know if documents are returned to you. This is one of the situations where you really have to be on the system on a regular basis. It's one of the real reasons that a solicitor's disk should not be used by other staff, because if they've used that disk to sign a document and don't use that disk again, aside from being contrary to the rules, they may never know that a document's been returned, because if the lawyer's not on the system, that's where the document will have gone. It will have gone to him for correction. Common errors are mentioned, I think, in one of the papers. We found in London, of course, because we were first to go, that a lot of documents were being returned because we were, for example, making spousal statements and incorrectly spelling the name of the spouse, incorrectly spelling the name of the charger in a mortgage in that it didn't match the transfer, and so on. The registry office officials were very good here. They would return documents to us that they really didn't have to return, but no, we would want to correct. I think that procedure is slowing down, so that my understanding is that documents will be returned only now if they cannot be registered because of a contravention of requirements for registration. Those are some, I hope, practical tips for you. I want to wish you luck, the people that are going to come online. I want to encourage you to, as soon as the system becomes available to you, get started. Use the practice module. Encourage other people in your jurisdiction to close electronically. Don't wait for the second reg to fall and be in a panic mode to get that first electronic registration done. This is like any other software. It's once you've made the same dumb mistakes a few times, you realize what you're doing. It is very user-friendly once you've accommodated yourself to the system on a regular basis. Thank you for inviting me, and I'll send it back to Toronto.
Can manage as well. I'd like to constitute our question and answer panel now so that we can give you guys also a chance to participate. I'll quickly introduce some of the people you have been introduced. I'll introduce those who haven't. Rosemary, of course, Rosemary is going to moderate the question and answer panel. Rosemary is with Oslers. And Rosemary has been in this e-reg thing for at least the last 4 or 5 years, and she's part of a law clerk group here in Toronto as well that sort of canvasses issues that come up as we sort of delve further into e-reg, so very knowledgeable. As well on our panel, we will have Sandra Matthews. Sandra Matthews became a conveyancer over 20 years ago and is currently working as a law clerk at Oslers. Sandra has been dealing with e-reg issues for the past 3 to 4 years. We've also got Bev Fodor. Bev was a registration clerk in the London Middlesex office during their conversion, pilot period, and ultimately the mandatory phase in early 2000. Bev joined the ministry's e-reg team over 2 years ago. We also have Kristen Pearson, who's been with Terranet for 9.5 years. She's currently the manager of professional services group, who's responsible for assisting clients of the TerraView software to prepare for remote searching and electronic land registration. And then we have Randy Reese and Alan Silverstein joining the panel as well. Over to Rosemary.
Thank you, Silvana. I'd just like to deal with a couple of administration details. I believe we lose our remote connection at about 1, so we will have to wrap it up soon. We'll keep it going as long as the member can do it here, and if the remote can stay with us, that's great. As Silvana mentioned to you, I am involved with a user group here, and we've come up with a number of questions and problems, and I'm going to raise some of them to start off, and people have been submitting others. As I get the opportunity, I'll be going through the remote locations, so if those people can be ready to give us their questions, that would be great. We're not going to get to all of the questions, there's no doubt. I would encourage all of you, especially those in the remote locations who haven't had an opportunity to use eReg, to form user groups with your colleagues, and don't hesitate to include people from jurisdictions where eReg is already available. This is how we've been doing it here, and it really works. Somebody out there has done it, so get your email pages and send out a mass emailing to your group saying, who's done this? I've got to do it tomorrow. So let's get on to some of the questions. One of the issues that has come up, and perhaps I'll address this to Kristen, and perhaps even Randy as well. It's kind of a ministry internet issue. We often encounter this situation. The ministry would prefer that we don't attach documents as schedules, especially court orders and so on, and instead rely on the compliance with law statements, and Stephen had indicated some of those, especially on vesting orders. Some lawyers are reluctant to do that. The vesting order may specifically eliminate certain encumbrances or may indicate that certain encumbrances will continue. And we just don't want to, make a statement that it's vested in so-and-so unequivocally. We'd like to have that order registered. Some of them are very long, and it's a court order. We can't manipulate it to fit the system. How are we going to deal with that?
Well, I think I'll address what's acceptable in tier review as far as attachments goes, and then if Randy has anything to add, he can certainly do so. In tier review with attachments, there's 3 different forms of attachments you can attach. A TIFF, which is a scanned image, a text, which is something you can create in any word processing software as long as you make sure that you save it as a text file, and a PDF. A PDF file requires a PDF writer in order to create one. There are limitations, and the limitation is a 1.5 meg file for a TIFF, for a text, and a 2 meg file for a PDF and a TIFF. What I would suggest that you're making sure that you do for your TIFF files, if you are finding that they're a little longer, make sure you're using the compression availability in your scanning software. Randy, do you have anything you want to add?
No, Kristen, I think that covers it pretty much. If they go over the file size, and I don't think we see an awful lot of those, but if they do, they can be filed at the registry office as evidence and then referenced in the document. So if you get some that exceed that file size, and I don't know how many we've had, but I don't think it's been that often. There have been.
Thanks. Another question that has come up, for me anyway, quite recently, is with the power of attorney. I think there's some thought that when we register a power of attorney, we are simply electronically registering what exists in the paper system. Others believe that, in fact, the power of attorney is being created in the electronic environment. It does say, I hereby appoint. Questions arise, does it meet the provisions of the Substitute Decisions Act? Where are the witnesses? And does it revoke others that are out there? What should we do? Randy?
I know this issue's come up, and I forget how long it's been around, but there is the ability within the electronic registration system to file a power of attorney document. The question, I guess, there's some questions that have arisen around, I guess, the legality of that or what effect it has. So the position we've taken until those issues are resolved is that you can either file electronically or you can come into the office and file by paper. You have that option. I think it was one of the items I'd listed in my presentation that you could do either way.
Thank you. We've heard a lot today about compliance with law statements. Why can't we can make a statement dealing with the date of somebody's death? Why, when company ABC has changed to XYZ through amalgamation or amendment, why can't I make a compliance with law statement dealing with that?
And I think, Rosemary, that's a good question. It is something that we're looking at and is under advisement. I don't have an answer for you right now, but it is something we're looking into, and hopefully we'll get some resolution to it soon.
Thanks, Randy. Sandra is a law clerk in our office and has dealt with a couple of these issues. Sandra, we tried to register a mortgage. It was in excess of $3 billion some time ago, and everything went strange. The consideration wasn't quite right. And then after that, when we tried to pull the parcel to verify that that mortgage was in fact registered, we couldn't. What is that all about?
There is a restriction on the TerraView software where you receive a message that instruments cannot be viewed, and you have to contact the customer service. And if you conduct a search of a property that has an instrument exceeding $2.1 billion, you won't be able to view any of the instruments. So you have to then contact the registry office or get an agent to get the parcel page for you. And then you could go back through the TerraView system and get a reversal on the charge because you wouldn't be able to receive any of the instruments. I understand that there is a patch that everybody has to download, but until all users have downloaded this patch, it won't, we still have this problem.
Kristen, do you know when it might be expected that everybody will download?
I can't give you an exact date because we don't have the control over when people do download, but once TerraView 4.2 is retired, that limitation will be lifted from the software, so by the end of the year.
Good. Okay, so if you are looking at a parcel and it's frozen, do consider all those options. This is one of my personal pet peeves. I realized after some time, I think, a number of registrations, that my registered duplicate document that is printed from the printer in our office after I've registered, in fact says receipted, mentions the date and so on. I did learn that after certification it says registered, but I always thought it was registered on the date that I pressed the register button and it was accepted. The Land Titles Act has a number of provisions where, an example I think is in 93, it says a charge when registered confers upon the chargee an interest in the charger's land. Do I have a registered charge when my document says receipted?
And I'll try to address that, Rosemary. I think part of it may just be a fact of terminology. We have not changed our practices from paper to registration in terms of certification. If you look at a paper document, it gets stamped at the counter, and it says on there receipted on that stamp. You also get your registration number at that time. When we certify those documents, or not certify the documents, but certify title, usually our practice in the paper world that one of our clerks who does the certification will initial the document. In the electronic registration world, when you submit it, it's, if you look at the printout, it says receipted. When we certify title, there's a process that's done overnight that says that the document, instead of receipted, is now registered. Now we've certified title. I just brought a section of the Act that I will refer to in the Land Titles Act. I think it's subsection 78.3. And it says that the time of receipt of the instrument shall be deemed to be the time of its registration. Now it talks about some other things in front of that about certification, but hopefully that will help answer your question.
Thanks, Randy. I'm going to move to a remote location. Before I do, there is a question for Caterina Galati, but I'd like the remotes to give some thought to whether they have questions. I'm going to be calling on Barrie, Kingston, and Niagara after this next question. Caterina, a question has been raised with respect to the Law Society's guidelines or procedures that would keep a lawyer who's acting outside of the main transaction. There's a purchaser and a vendor, but then there's a second mortgagee, so there's another party involved. They may not have been part of the DRA, they may have been brought in at the last moment. What impact do they have on the deal, and what part should they play in the transaction should they get in the DRA?
The guidelines themselves don't specifically address the private mortgagee situation, but it's a question of cooperation. It's, I'm going to assume that the main issue is the closing, how that's going to occur. The guidelines do talk about having a three-way DRA where all three parties are involved. If that doesn't work, as we did in the paper system, you could reach arrangements with one of the lawyers in the transaction whereby you release funds in escrow and there are agreements that that lawyer keep you advised. The third way is, and this is in my view, a last case scenario, you meet in one location and you exchange documents, funds, and keys. It's a give and take process. And if you're the mortgagee's lawyer, you have control of the funds. So you're in a pretty good position, I think.
That sounds good. Thank you, Caterina. I'd like to move to Barry to see if there are any questions there. Any questions for Barry?
Hello, can you hear Barry?
Yes.
There are no questions in Barry, thank you.
Thank you. Let's move to Kingston. There is a bit of a delay, just so you understand. It's a few seconds.
The other way around, who has questions?
I think we've got to kind of go to each one.
Are we with Kingston?
Saying we have a cell phone.
Okay. Perhaps we could try Niagara. After Niagara, I'm going to move to Waterloo and Windsor, and then we have a couple more questions here in Toronto. Do we have Niagara? Any questions in Niagara? Niagara, it looks as though we have you. Do you have any questions?
Just have somebody call.
All right, let's next go to Waterloo.
That's true too. If somebody wants to ask questions, they just have these locations, somebody's cell phone. It's going to cost $1. Losing everybody here. That's the problem.
Nothing in Waterloo, so we'll move to Windsor. By the way, we may just be having some connection problems. I just want to confirm that there's some websites that I've got in my section. I think it's tab 14. And as Randy's mentioned before, and as Nick did as well, through the websites, there are customer service numbers. You can speak to human beings to raise your questions if your user groups and so on can't give you the answers you need. I don't think we're going to get to all of the Toronto questions, but we'll just take one more. Do you have one that's good? Shall I just raise one of my own then? Okay. I'm going to just raise a question that has come up before, but again, it's a situation where it seems to me anyway that the system is so different from what it used to be before. And perhaps I'll address this to Alan. When I register a transfer or take a transfer from a vendor, who has a spouse who's supposed to be consenting, I don't see that spouse's signature on the transfer. The transferring spouse does in fact say that his spouse has consented, but how do I know?
Well, first of all, there's no human signatures, period. But the more important issue is that you don't even get the ability on the acknowledgement and direction to get the spouse to sign. I think there's a flaw in the acknowledgement and direction. There are document preparation programs that do deal with that. What we've done in our office is very simple. We've simply got a form, and when we have an acknowledgement and direction in a situation like that, we simply photocopy the wording onto the form and then make sure we have it signed by the spouse. But again, the other side will never get the signature of the vendor or the spouse, and they're going to rely upon the statement. But as the vendor's lawyer, I'd want to make sure I have something showing spousal consent, as in the old form, and that's what we simply do until the problem is fixed.
Thanks, Alan. And I have another question for you. How do you remove an execution? The thumbnail description says it's subject to an execution. How do I get rid of that?
There is a bulletin out there. It's hard to find, but I've got it in the office, and it deals specifically with the process. And I think one of the papers mentions that you basically say you've searched for the execution, it doesn't appear, and then you make the application to amend the register to have it deleted from the thumbnail. What you have to remember, though, is doing that is not sufficient. You've also got to amend it in the legal description. Otherwise, if you don't change in the thumbnail, what's going to happen is you've deleted it there in the one instrument, but it's continued to appear in the description in the future. So it's really a two-step process.
Thanks, Alan. I'd like to go back to Windsor. I think we've established our connection. Just to see if, are there any questions, Windsor? Okay, well, thank you for joining us anyway. We hope it's been of use to you. I think we're at our 1 o'clock time frame. As is the case with all of these, there are always so many questions, and this is going to be an ongoing process for a number of years. I want to thank the panel especially, who've spent a lot of time, although we've been rushed through our questions, but spent a lot of time trying to address issues that are concerning a lot of us. I also want to thank all of the speakers. This has been a really comprehensive program. We wanted to try to get as much in it as possible, and I want to thank all of you for taking the time and showing us that obviously this is worthwhile doing. And so enjoy the rest of your afternoon.